Today, we're cracking open one of the most powerful tools in the entire legal system, specifically from Philippine law. It's called Rule 57, or preliminary attachment. This is a legal move that can literally freeze a person's assets in their tracks, and we're going to break down exactly how it works. Okay, let's get into it.
So just imagine this for a second. You've got a rock-solid case against someone for a massive amount of money. You are absolutely sure you're going to win. But then you hear something, a rumor. They've booked a one-way ticket, they're leaving the country, and they are selling off everything they own. What do you do?
You see, here's the problem. The wheels of justice, well, they can turn pretty slowly. A final decision from a judge could be years down the road. And let's be honest, a win in court means absolutely nothing if the person you sued has just disappeared, along with all their cash and property. You're left holding a piece of paper that says you won, but your pockets are completely empty. This is the exact nightmare scenario that Rule 57 was built to stop. So, how does the law give you a fighting chance here? Well, it offers you a kind of preemptive strike. It's a way to lock down your potential victory before the main legal battle is even over. This is what's known as a provisional remedy. Think of a provisional remedy as a temporary support system for your lawsuit. It's not the main event, it's an ancillary tool, something that runs alongside the main case. And its entire job, its whole purpose, is to preserve the situation as it is, to make sure that when you finally get that favorable judgment, there's actually something there to enforce it with. And that brings us to the star of our show today, preliminary attachment. This is a very specific court order that lets the court take temporary custody of a defendant's property. We're talking bank accounts, cars, real estate, you name it. It basically acts like a legal security guard, standing watch over those assets to make sure they're still around when you finally win your case. Okay, so this sounds incredibly powerful, right? But how does someone actually get the court to issue one? It's definitely not automatic. You have to prove to the court that you have solid, legitimate grounds for taking such a drastic step. Now, under Rule 57, the court needs a really good reason to grant an attachment. And if you look at this list, you see a theme, don't you? Someone is about to flee the country to avoid paying debts, someone embezzled money, there was fraud involved in the original deal. It's all about bad faith, deception, and fraud. This isn't just for any old debt, it's for situations where it looks like someone is actively trying to cheat the system. Now, because this remedy is so extreme, the court demands two crucial things from you, the person asking for it. First, you need an affidavit. This is where you swear under oath that one of those specific grounds we just talked about actually exists. You can't just say you have a hunch. Second, you have to post a bond. Think of this like an insurance policy for the other guy. If it turns out you were wrong and the attachment wasn't justified, this bond is used to pay for all the damages you caused them. So far, this all sounds pretty one-sided, doesn't it? But the law always tries to find a balance. So what if you're the defendant? You wake up one morning and find out all your assets have been frozen. Are you just stuck? Nope, you're not helpless. The rules give you a very clear way to fight back. The main way for a defendant to defrost their assets is laid out right here in Section 12. You file a motion with the courts, and then you put up security of your own. This can be a cash deposit or something called a counterbond. You're basically telling the court, look, you don't need to hold my property hostage. I'm posting an equivalent security right here that guarantees I'll pay if I lose. So please, release my assets so I can get back to business. And believe me, the courts are incredibly strict about following these rules to the letter. Take this 2022 case. A company tried to use a standby letter of credit instead of the required counterbond. The Supreme Court said absolutely not. The rule says you need a counterbond, and you can't just substitute it with something else, even if it seems financially similar. It's a huge reminder that when it comes to this stuff, the procedure is everything. So, as we've seen, preliminary attachment is a really formidable weapon. On one hand, it protects people from getting cheated out of what they're rightfully owed. But all that power also comes with some serious risk, which makes this a true double-edged sword. And here is probably the most shocking part of Rule 57. An order of attachment can be granted ex parte. Now, that's a Latin term that just means from one party. It means the judge can issue the freeze order based only on what the plaintiff has said, without even telling the defendant or hearing their side of the story first. The logic is simple, right? If you warned them, they just hide all the assets. But it's also what makes this remedy so incredibly drastic and so potentially dangerous. To really get what makes this so unique, it helps to compare it to something else called execution. Just think of it like this. Preliminary attachment is the preemptive move. It happens before there's a final winner, and its only job is to secure the property. Ordinary execution, that's the final blow. It happens after you've already won, and its purpose is to actually satisfy the judgment, which usually means selling off the assets to pay the debt. And because this remedy is so harsh, and because it can be issued without hearing from the other side, courts are extremely careful. This quote from the Supreme Court really says it all. You can't just walk into court with vague accusations. A judge needs to see concrete, specific facts that point to real fraud. Just throwing around general claims, mere abstractions, is nowhere near enough to justify freezing up someone's entire financial world. So in the end, we're left with this really fundamental question. Is preliminary attachment a necessary shield, the only thing that stands between legitimate creditors and getting nothing? Or is it a dangerous sword, a weapon that can absolutely cripple a person or a business based on allegations that still haven't been proven in a court of law? The system tries to strike a balance, but it's a tough question, and one that's definitely worth thinking about.